think we're going to proceed in the following order since plaintiff filed first. That will go first. And then we'll hear from the city, and then you'll have a chance to reply, and you'll have a chance to reply. All right?
Certainly.
Okay.
Good morning, Your Honor. My name is Judy Endejan. I'm from Graham and Dunn, and I represent the plaintiff, Komo TV. With me, I have Ms. Tracy Vetter, investigative reporter from Komo, who submitted the Public Records Act requests at issue here. And next to her is the Vice President of News for Official Communication and the News Director for Komo, Polygon. Your Honor, do you have a preference for where counsel appear to argue at the bar or from the table?
I don't, but I think that a court reporter would prefer if you argued at the bar. And I'll tell you the reason for that is because it's very hard to hear in this courtroom. I invite anyone who cannot see or hear counsel if they're at the bar to sit in the jury box. If you wish to do so, you're free to do that.
Thank you, Your Honor.
And that's true for anyone in the back. If you wish to sit in the jury box instead to hear better, you can.
And Your Honor, I will be using a PowerPoint presentation, and for the court's convenience, I have copies of all of the slides that I'll be referring to.
Sure.
Your Honor, the Seattle Police Department has stonewalled every recent attempt by citizens, including members of the media, to obtain in-car video recordings that record all interactions between Seattle police and citizens. Now, unless you've been living in a hermetically sealed vacuolock bag beneath the viaduct for the past 3 years, you're probably well aware that a lot of these in-car videos have been quite controversial because some of them have documented Seattle Police Department misconduct and other misdeeds. You're probably aware that the Seattle Police Department was the subject of a Department of Justice investigation and report last December that relied heavily on in-car videos. Now,
I think the parties can assume that I'm very familiar with in-car videos, both from my job as a judge and my former job as a lawyer.
thank you, Your Honor.
Yes.
Well,
so many of them.
suffice it to say that it's not an understatement to say that the Seattle Police Department, or SPD, is not particularly crazy about having the public have access to the in-car videos, which is really quite ironic because one of the reasons for purchasing the in-car video system earlier this decade was to provide protection for police against claims, citizen complaints that might be unfounded, and also to provide greater public accountability. So against that backdrop, in the summer of 2010, Tracy Vetter of Komo TV began questioning the SPD about the in-car video system. She first met and talked to Sean Whitcomb, who is the media relations person for SPD. And she told him that what she was looking for was a database of the in-car videos. And Mr. Whitcomb passed that along. And it was no surprise that SPD's reaction was less than helpful. In fact, SPD's actions ever since that time have been nothing but unhelpful and in violation of the Public Records Act. There's no question that these in-car videos are public records. That's never been contested. But Ms. Vetter didn't initially ask for the videos. She first asked for database records that listed the videos so she could gain an understanding of kind of the universe of what these videos were, and so that she might be able to refine any further requests. Now, SPD apparently maintains, unsupportably and has throughout this, that somehow or other, Ms. Vetter, they didn't know the true nature of Ms. Vetter's request. And therefore, because she didn't use the right words, she didn't use the word database in her request, but she used words video logs or lists, that they really didn't know what she was asking for. And therefore, because Ms. Vetter asked for X document, SPD said, well, we can't give you X document, even though they knew Y document contained the information that was responsive to her request. So instead, SPD did give exactly what Ms. Vetter asked for to a citizen requester, Eric Rackner. because he used the right magic words to request the database. Now, Mr. Rackner, you have to understand, Your Honor, has 10 years plus of IT experience and had sued SPD previously to get videos regarding him. So he knew how to frame the request in such a manner so that SPD couldn't wiggle out of it on a semantic basis.
Now, you know that SPD contends, and I'm going to ask questions as we go along to move things along, that Rackner's request, which was quite specific because of his knowledge of Microsoft SQL, thank you, was different in that it did not contain information specific to officers, a badge, dates, could not be searched in that way. They contend that was the difference between Rackner's request and Ms. Vedder's request. So why don't you respond to that?
Well, Your Honor, I'd like to do that by going through, if I would, some of the chronology, because that's a completely bogus claim. First of all, starting out with some black letter law, I'll go through this quickly. It's clear that they are to make public records, SPDs to make available public records, and they're not to distinguish among persons requesting. Just because it's the media that they might dislike, that doesn't mean they have to disregard requests. The next slide, please, shows that prompt responses are required. That didn't happen here. The next slide, please. This shows the obligations that they are to provide full public access to public records and to provide the fullest assistance to inquirers. Next. Now, there's no question, and I'll go through this brief quite quickly, that SPD bought a database when it bought the Koban in-car video system. Right. And these next three slides show that, in fact, the purchase order showed that they were intended to acquire and did acquire a database. So there's no question that a database existed. So if you go to the next slide, Ms. Vedder, in the course of her public records request, asked for a copy of, quote, one video log, which they, of course, said didn't exist, but gave it to her anyway. If you go to the next slide, what does this show? Now, it shows, first of all, they call these things logs, video logs. And it also will show that it's clear that you can pull out information. It says retain, unretain. They clearly had the capability back then to print out records that would identify retained reports. And then finally, if you go to the next slide, Mr. Rackner, this is a slide about Mr. Rackner got. And it shows pretty much the same data. It's the database. So there's no question the database existed. Their position is, but you didn't ask for the database. We didn't know you wanted the database, which is an argument that's really too cute by far. If you go to the next slide, please. Now, Mr. Whitcomb knew, and actually I'll have you go forward, Robert, one. Tracy Vedder told Mr. Whitcomb, ultimately would like to have a digital database of all of these videos. So she tells Mr. Whitcomb that. Go to the previous slide, Robert. So what does Mr. Whitcomb do? He sends this on to the powers that be within SPD, specifically Assistant Chief Reed, and says, gee, I don't see any harm in accommodating her. Well, what is the SPD's reaction? Nice try for Komo. That sort of set the tenor of their whole reaction to the chain of events that subsequently occurred. All right, and so it's disingenuous for them to claim that we didn't know what she was looking for, because if you'll notice what we highlighted at top, Sheila Friend Bray, who is the Chief SPD Public Records Officer, she was made aware in July of 2010 exactly what Ms. Vedder was requesting. Okay, could you go 2 slides to the next one? Well, this just highlights it. This is a pull-up of Ms. Vedder's request for Mr. Holcomb. If you could go to the next slide. All right. Ms. Vedder also asked SPDG, could I talk to somebody so you can kind of explain to me so I can figure out what to ask for? That was denied. Next slide, please. She asked for the user's manual, and the next slide to that shows that they told her it was the Koban system, and they told her that she couldn't see the user manuals because of copyright law, which we won't even go into that, but go to the previous slide. somebody said, well, she can see it, but not copy it. That's not what they told her. They said she couldn't see it. So she was denied access to people with knowledge. She was denied access to the user manuals, and she had no ability to, quote, frame the request right. Okay, so August 4th is the first request that formal public records request that issued here. And she requests all Seattle police officers' log sheets, and you can see that. What is the response? How does SPD search for this? Well, they send one request to the person in IT who is not responsible for the Koban video database, a Mr. Alcayaga. And that's all. He writes back and says, well, we don't keep them. All right? That generates the response. And if you go 2 slides down, Robert. One sentence response. Oh, a search of the files says there are no records. That's all they do. All right. Ms. Vetter says, well, yeah, okay, well, let me ask for it a different way. So, on August 11th, she submits her next request. Robert, the next slide, please. A list. Oops, no. Next one after that. Here we go. Okay. On August 11th, she asks for a list of all digital audio recordings. It's clear she's asking for data to be released in a searchable electronic format, organized in searchable by date and other reasonable fields. Well, now, this generates maybe a little more response. If you go to the next 2 slides, or 2 slides after that, Robert. They do have internal communications, and Ms. Fran Gray asks people within IT, can we do this? And they say, well, we don't really know. We can give her certain data by certain sorts of reports, but we can't give her everything, and maybe we should check with Koban. And she tells them, no, stand by for right now. Don't go any further. Don't look any further, okay? So then this generates the August 18th reply, which is, go one more down. There it is. Well, they're unable to query the system. We can search by individual officer name, date, and time only. We can't generate these reports, thus we don't have any records. So they tell her, well, we can give you something by, not what you asked for, but they don't give it to her. Also, there is no evidence, and they never contacted her to say, gee, I really don't think we understand your request. If we can help you here, this is what we've got, will this satisfy it? No, they just summarily denied at every step of the game. So, then...
Isn't this answer really saying we're not going to create a record for you?
No, because I think what it's saying is we don't have any responsive records. We don't have any database records. That's what they're telling her. And I guess the question becomes, Eric Rackner asked for the specific Koban database.
Well, the real question is, I think, you've characterized the issue, and I think this is right, is that the burden's on SPD to show that they're more reasonable, right, whether or not they understood the request.
And also, Your Honor, under the most recent case of, the Spokane, the Neighborhood Alliance case.
Right.
Yeah, the agency bears the burden of showing that its search was adequate.
Right, I agree with that.
Okay, so then going forward, Ms. Vetter not being able to get any information that would help her identify what she's seeking, because she was basically just sort of rather blown off. Nobody talked to her. Nobody said, gee, how can we help you find this? So she submitted a request for the video recording. So if you could go to, there we go, September 1st, 2010. She asked for the video. She said, well, okay, if you're not going to give me the list, then at least give me the videos. Well, that's when all hell broke loose. That's when war was declared, frankly, I think, at SPD. The SPD basically said, wow, we can't do that. But what they did do during the month of September is they actually picked up the phone and they called Koban. And Koban, and to say, well, what can you tell us? How can we get this? So, if if you go down to, okay, shows that they went to contact Koban. Go to the next one, Robert. All right. Koban writes back right away and says, sure, not a big deal. We can give you a script on manual retained videos for free. We can have it done in a day once it's in a spreadsheet. And that would have solved the database problem that we've just been discussing, Laura. But they, and Mr. Hill said, well, I'll forward this along to our requester and let you know what they decide. Now, the requester is Ms. Vedder. She was never told any of this. Any of this. Instead, on October 1st, if you could go to that slide, which is number 32, Robert, 2 slides down. There we go. As we have previously stated to you in our August 18th response, we're unable to query the system to generate a retention report. And without this, we can't respond to your request. Therefore, we have no documents responsive to your request. Now, besides the fact that this sort of borderlines on sort of Tweedledum Tweedledee logic, it's a lie because Ms. Friend Gray knew as of October 1st, 2010, that they had the capability to query the system. So rather than correct her statement in her August 18th letter, she just perpetuated it and hid the truth. She did not tell them that Koban had the capability to draft and write a fairly simple script to give her this response. That is saying to her, we're not going to give you any videos. There's no other way to interpret that. And that appears to be saying, despite various mischaracterizations, that, well, because, and it's sort of illogical, because we can't find them, therefore they must not exist. Now, what is also quite peculiar about this response is that nowhere is there any mention that the video can't be released for a 3-year period because of RCW 9.73.090. And as a matter of fact, that didn't surface until 6 months later when that pesky Komo persisted in trying to get to the bottom of this. As a matter of fact, they told Komo that Komo could appeal to Chief Diaz. Komo appealed. Took 2 months, got a response from the chief's legal advisor that basically parroted this and repeated that we don't have the ability to query the system, which was a flat-out lie and a falsehood. So, going into 2011 then, what we have before the court are the 3 denials at issue here. The denials of the database information requested and the denials of the videos. After contacting the Seattle City Council, sort of, because it doesn't take much more than common sense to scratch your head and say, well, wait a minute, I can't get these videos because SPD can't find them. That raises serious evidentiary issues and all sorts of issues. Of course SPD could find these retained videos. They just were not going to give them to Komo. All right, so then we flash forward to March when Mr. Conlon and Seattle City Council actually contacted them and said, hey, something's kind of not right here. You know, you should have a list, there should be something. And so SPD for the first time says, oh, by golly, you're right. We do have these videos, but we can't give them to you because for the very first time, there is this statute that prevents us from giving it to you for a period of 3 years because we have to make sure that any possible litigation that could be brought can't be brought. Now, the catch-22 to that position is, this is the beauty of their position, their official policy. And if you could go down, Robert, I want to highlight, well, it's the policies and procedures manual, Your Honor. They did give Ms. Vedder the policy and procedures manual, and that would be page 40, Robert, page 40. The official policy of the Seattle Police Department is that the system only retains archived imagery for 3 years, and at the conclusion, the data is automatically deleted. Nowhere in any pleading in this case have they said that that policy is not true and not correct. So the natural implication of this is, well, we can't give you the videos for 3 years, but by the time we can, they're gone. Too bad. So also, if you look through their policy, Your Honor, there is nothing that indicates that there's any limit, this 3-year limit. Nothing. As a matter of fact, it talks about making access to citizens requesting these reviews. So it's our position that the other statute, quote, exemption, quite conveniently was invented to provide a basis to withhold the videos. And again, SPD bears the burden of justifying any claimed exemption. SPD also bears the burden, which they did not do, of providing a list of all videos that they're not going to give to us on the basis of that. So that's a further Public Records Act violation. All right, so where does that leave us, Your Honor? Well, I think I've discussed the failures associated with how they handled Ms. Vetter's request for the database. I mean, they did no adequate search. They didn't talk to her. They didn't question her. They withheld information from her. This is the classic hiding the ball case. You didn't ask for it right. You didn't ask for it. You used the term log or list as opposed to database. And they're obligated to construe public records requests liberally, not narrowly, not hyper-technically, not in any way, not in the way that they construed it, which is to say, well, we can give you, well, our system can do this, but it can't do that. When Mr. Wagner submitted his request, they contacted him to make sure that they were going to be providing him with what they wanted. They didn't do that to Ms. Vetter. So then, and we submit, Your Honor, that there is sufficient evidence from which to conclude that there is a bias against the media. SPD has been subject to not particularly favorable press in recent months. It's clear that every public records request, if you look at the log sheets that are an exhibit to my declaration, Your Honor, they identify her as a member of the media, the requester. So it's not unreasonable to infer that they're going to slowball and do whatever they can to prevent these videos from getting into the hands of the media. Now, the Public Records Act treats a failure to properly respond as a denial. They failed to properly respond. That's a denial. Under all of the authorities cited in the Neighborhood Alliance case, they have violated the letter and the spirit of the law here. Now, separate and apart from that, they admit the videos exist, but they say they won't produce them because 973090 constitutes an other statute. Now, to agree with that, you would have to basically ignore fundamental black letter law in the Public Records Act that says exemptions are to be construed narrowly. If there is a conflict between the Public Records Act and, quote, an other statute, the Public Records Act trumps. As a matter of fact, Your Honor, the city's even conceded that position in a memo in their analysis.
So let me ask you, I think that was made in settlement, but let me ask you this question. You've argued, and you just argued, that it's not a reasonable interpretation. What is a reasonable interpretation of 973090? What would be a reasonable interpretation of that statute for the city to adopt?
Well, given the public records directives here, what they would have to do, and I would submit that they could have, would have, should have anticipated this in purchasing the Covant system, which has varying fields of data that you can indicate, and update, that they keep a record of when a video, in fact, is subject to criminal prosecution or civil, and that the burden be placed on them. The presumption should be the video is disclosable unless there is an actual pending civil or criminal litigation. Under their approach, they say everything on a blanket basis has to be withheld because there is a remote possibility that someone could bring a civil action within the 3-year statute of limitations. That's overly broad.
Well, even now, criminal cases, the criminal records, which are different than the video and not under the statute, aren't released until there's a decision on a criminal prosecution. Then, once that decision is made, they are released. So that seems to be, your interpretation is even broader than that policy, it sounds like, or you would...
No, maybe I should be, let me clarify that. Sorry,
go ahead.
No, our interpretation would be, it is possible for SPD to identify those videos which are subject to existing criminal and civil litigation. And because those fall within that narrow exemption. All the rest of the universe of videos don't fall within that. And they should be presumed to be disclosable. Now, the city makes an administrative inconvenience argument here, which is not tolerated under the Public Records Act. The Zink versus Mesa case makes that clear. It's also not fair because they have the capability in their system to designate when, or they could set up a new field to designate this video, criminal prosecution, or civil. I've also, they know how to do it, Your Honor. If you go forward, Robert, to number...
before you make that argument, I think I'm going to hear from the city, and then I'll ask you to respond, talking about the administrative convenience issue.
Okay, and Your Honor, I wasn't finished with my other statute argument.
Okay, all right. Go ahead.
Your Honor, because the other statute exemption is somewhat problematic, the court has, established 2 criteria for when something can be deemed another statute. It's an other statute if it requires non-disclosure forever of the entire document, which in this case that does not apply to in-car videos.
Right.
And also it can't conflict with the policy of the Act. Now, I can't think of a clearer conflict between the underlying policy of the Public Records Act than the city's interpretation here. Because the purpose of the Public Records Act, and I know you know this, Your Honor, is to basically help promote public accountability and transparency.
Okay, and I agree with you. And that's why I asked for what you think the interpretation should be. I was trying to find out from you what you thought a reasonable interpretation would be of 973 on 90.
The only possible one is when there's actual civil and criminal litigation,
right.
Not the universe of all of them for a 3-year period.
For possible litigation.
For possible litigation. Those words aren't in the statute, nor is this 3-year limitation in the statute.
Would you include ongoing investigation that has not resulted in litigation in the criminal arena or not?
Well, Your Honor, that would be covered by a different exemption in the Public Records Act. That would be covered by, if it's an ongoing police investigation, that's covered under the investigative records exemption.
Right.
So it really doesn't intersect with 973 and 090. Okay. And Your Honor, the legislature knows how to specify when something is to be considered another statute. For instance, I looked in the Public Records Act desk book, and they have an appendix that lists all the known, quote, other statutes, exemptions. 973-090 is not in them. And if you just pick a handful at random out of there, it's, for instance, it's 82, RCW 8236-450 specifically says information from the tribe or tribal retailers received by the state shall be deemed to be personal information under RCW 4256-2303B and exempt from public inspection and copy. The legislature knows how to designate and say it's not subject to the Public Records Act. RCW 50.13060 specifically says particular information is exempt from public inspection and copying under 4256 RCW. It doesn't say that in 973-090. So we would submit that the interpretation rendered by the city is not consistent with the Public Records Act. It's in conflict with it, cannot be harmonized, and it's flat out wrong. So accordingly, the Seattle Police Department shouldn't be allowed to withhold on a blanket basis all of the in-car videos that Seattle citizens pay for, that are critical. If you just look at some of the recent incidents that have occurred.
I need you to conclude because I need to move the city.
Thank you, Your Honor. I will reserve further remarks.
Thank you.
Good morning, Your Honor.
Morning.
I'm Mary Perry from the City of Seattle, and my colleague Gary Smith is here with me.
I didn't hear the name.
Gary Smith, and I'm Mary Perry. Wow, I've heard
Sure, again, you don't have to bow when you come forward.
I've heard a lot of accusations here. We're supposedly liars and really reprehensible people. But I want to just step back and look at this logically and reasonably. Actually, I think that Ms. Endejan should consider Occam's razor. When you hear hoofbeats, you should think horses, not zebras. Rather than accusing us, she should look at what was requested and what SPD did. If this is a matter of stonewalling, we sure went to a lot of trouble to stonewall her by meeting with her, by meeting with Ms. Vetter and Ms. Endejan, by providing customized programming at no cost, by providing individuals to sit with her while she looked at the system, because we tried to set up an independent console for her at our expense. Unfortunately, it didn't work. So then she was given access to the live system. It's extraordinary that this could be called stonewalling. I'd like to step back and talk about what the Public Records Act requires, and also about what our system was like in 2010. First of all, the Public Records Act requires that an agency provide access to identifiable public records. It doesn't require that an agency become a personal programmer or provide private research for a requester. What we're supposed to do is, if we have a record, we're supposed to provide it by copy, however, and give it to the individual. Here we have an incident where we didn't have records that were responsive to the requests. And there is nothing in the Public Records Act itself that requires us to do this kind of programming or to disclose records electronically at all. For example, there are two recent cases on this: the Meckling versus City of Monroe case and the Mitchell versus Department of Corrections cases. In both cases, the court held that the agency didn't have to provide them in the electronic format that was being requested. It was nothing compared to what Komo was asking us to do.
Thank you. One of the hazards at this courtroom is that there's only a single piece of sheetrock at the window between here and the outside, and it makes it very difficult for the court reporter when there's a fire truck or a police siren going by. Why don't you go ahead and continue?
Yes, Your Honor. In the Meckling case, the issue was whether or not it was feasible to provide unredacted emails electronically. The court didn't say you had to provide them that way, but just to determine on remand whether it was feasible. That's nothing like what we have here. In the other case, Mitchell versus Department of Corrections, the court held that the agency did not have to print out records that were already in electronic format, redact them, then scan them back in and produce them electronically. The court said you didn't have to do that. Again, that's not even close to what we were requested by Ms. Vetter. I also want to talk about the system and what it was like in 2010. And I will say that we have provided this information repeatedly to Ms. Vetter and to Ms. Endejan. She conducted discovery. It's in the discovery, but still don't seem to appreciate what we're talking about. In 2010, at the end of the year, August and September, when these requests were made, we had the in-car video system from Komo, outside vendor. We bought it with certain specifications, most of which were provided by the vendor because it was a kind of an off-the-shelf type of program. And what that allowed us to do was to, could we go back to this slide, please? I would really appreciate it. This one right here, because it's the view video logs, because this is really important. What we could do is we could respond to a prompt, a query and a prompt. And what we could do is we could search by the officer's name, the date, the time, excuse me, not the officer's name, but the date, the time, and the officer's badge number. And this is what we would get. You see, it's a list of 16, and it's a screen. You get a screen of 16. We could get up to 500 results at a time, no more. And they came out 16 at a time. In order to create a list, we would have to print them out and print them out 16 at a time, scroll down the next 16, print it, next 16 until we got to 500, then do another query prompt. That's what we were able to do. Now, if we were supposed to create a database from that, it would require essentially what the Meckling court said that the agency didn't have to do. We'd have to scan them in and somehow create a database from that. There's nothing in the Public Records Act that requires an agency to perform that kind of function. Also, you have to look at the requests that were made here. Ms. Vedder asked for very specific records, and unfortunately, the PRA holds us to strict liability if we don't provide what a requester asked for. So, the thrust of Komo's argument is that we're supposed to look behind every request that appears to be clearly written and figure out what it is they really meant to say, or else we're going to be liable months later, or even years later for not responding the way that they somehow thought they wanted us to. That's an unworkable standard. For one thing, SPD alone gets 4,000 requests a year. The city gets 9,000 a year. If we have to do that, and if every agency across the state has to do that, I don't know when we're going to be able to do the type of work that we also have to perform our functions. This is a summary judgment motion, so let's assume, for the sake of argument, that Ms. Vedder actually asked for a database. Let's start with the July 8th request, when she asked for the log sheets. I submit that when you ask for log sheets, and that's a record that actually existed, it's a record that's referred to in a policy manual, that you properly respond by providing a response regarding the log sheets, and the declaration of David Strong shows that we don't have those anymore. But setting that aside, even if this was a database, what database? It doesn't tell us. I mean, presumably we could go back and clarify, but it seemed to be clear on its face. So, if anything, this was a misunderstanding created by the requester, and we can't be held to that kind of standard. It would be impossible, because then the requester could come back anytime he or she wanted to and said, oh, that's not what I really asked for. Let's go to the August 4th request, or excuse me, August 11th request. That is the one where she asked for a lot of information. She wanted a list. Well, first of all, the list didn't exist, because that's what this is. This is the most list we had. And again, we didn't have to print those out, scan them, and produce them electronically. Also, she keeps talking about the list, this very simple little SQL server script. If you examine the declarations and the pleadings provided by Komo itself, that's not the list she was asking for. As a matter of fact, Ms. Vedder says in her declaration this was a virtually useless tool for finding records. That's not the list at all. It was just basically a data dump with just limited fields, 3 fields, that could be used as a first step in trying to provide Ms. Vedder with all of the information she wanted. Because in the spring of 2011, we were exceeding the requirements of the Public Records Act and going forward, trying to help her to give her access to the records she wanted. The same thing in September of 2010. She asked not only for the list, she asked for the videos too. And keep in mind, at the same time she's asking for this list, she's not asking for a Koban list. She's asking for all sorts of information. She wants the location, when it was tagged for attention, any other notation. She wanted it all. And as a matter of fact, she stayed with this same desire to try to correlate information from GOs and incident reports, CAD reports, with the videos. We didn't have the capability to do that.
Let me ask you three questions. First of all, when a governmental agency uses a computer program in order to keep its records, and the person isn't able to formulate a request for whatever reason, because maybe they're not asking the right question, is it your position that really the answer is from the governmental agency is limited to we don't have the record if it's not formulated correctly? How far is it for government's responsibility? And I recognize there's a burden on a government entity in a request being made, but how far does that go?
Well, Your Honor, I agree. And I absolutely feel that an agency cannot create a system that's purposely obtuse. But that's not what happened here. SPD went out and bought a Koban system for its in-car videos, bought it over 5 years ago, and in doing so, they got the state of the art at the time. And there was no system that correlated the incident report information with Koban. They bought it to meet the requirements that SPD had at the time, which was basically to search for specific videos and to pull those, download those for purposes of evidentiary use or public records requests from subjects, etc. And they never even considered having to go behind that and do some sort of huge report of the entire database. It had no operational need for it.
So let me ask what may be an obvious question. But if a public records act request is made, for example, for the John Williams case, just to use the most infamous example that's been cited by the parties, that specific request can be complied with by SPD, correct? If you know the date and you even know the officer.
Yes, Your Honor. Oh, certainly. We can do a request that pulls that video up.
Okay. And then, there's a counsel plaintiff has argued that there was a point at which you contacted Koban.
Right.
And then, after that first initial contact with Koban, you sent a response back saying there are no records that respond to your request. But at that point, it looks to me like, and I'm asking this, but I'm stating it, so this is a rhetorical question. It looks like at that point you knew that there could be a potential way to find a record. So while a record may not have existed at that point it looks like SPD, Seattle Legal Department, is taking affirmative steps to find out if such a record can be created. Do you agree with that statement? And if so, at that point, does that create a duty under the Public Records Act request for the governmental entity at that point then to respond with that information?
Yes, Your Honor, they did respond to that information. If you will look at what was said in the October 1st response, it says SPD is unable to query the system to generate a retention report that would provide a list of retained.
You need to slow down, or you're going to create a workplace injury for the reporter here.
SPD is unable to query the system to generate a retention report that would provide a list of the retained videos. Without that capability, we're unable to respond. Now, you're going to have to combine some information here, synthesize information, if you will. Also looking at the December 10th response to the appeal. That says that we had no capability to search for tagged records only. Without this capability, we can't create a list of retained videos and know what videos should be downloaded. Now, taking this one step further, if you look at the email that Ms. Endejan seems to think is some sort of smoking gun from Alan Chen, I think that was on September 14th. It says, Koban can provide a SQL Server script for SPD at no cost. But it also says a lot of other stuff. It says, to copy the above videos to an external hard drive, however, it will take some real programming. And they say that's going to cost about $1,500. They also say we're going to need additional work to provide the videos and the information requested with those videos. And that says we're going to have to meet with the CAD vendor and see if it's feasible to integrate CAD for data exchange. That, first of all, there's no requirement that we compile records from 2 different systems and produce a 3rd record for the individual. But also, who knew whether Versatern was willing to do this? As a matter of fact, in the SPD's experience, Versatern doesn't like to do this sort of particular programming. So this was all presumptive. Who knew if this was possible? So what SPD responded on December 10th was, okay, we can't do it. We don't have it. You're asking for something that does not now exist. But here are a couple alternatives. Why don't you ask for them the way that we keep them? You can ask for them by the name of the officer or badge number, or by time and date, or alternatively, how'd you like to work with the vendor? And you can pay for the special programming because that's allowed under the Act. As a matter of fact, the Public Records Act states that we have to find identifiable public records, which case law defines as reasonably locatable records. And if you look at the model rules of electronic records, now these are not binding on local agencies, but they're certainly persuasive. It says a reasonably locatable electronic record is one that can be located with typical search features and organizing methods contained in the agency's current software. We didn't have those typical search features and organizing methods in our current software. I know we need to move this along, but let's go to what happened after December. Rather than take SPD up on its offer to work other ways to get the records, Komo complained to the council. And I do want to say one thing about the need to state an exemption. An agency doesn't have to state an exemption if there's no record. That makes no sense at all. You only state an exemption for the records that are actually exempt. So there was no need to bring up 973 at that point. Okay, moving forward. SPD started working after the March 4th letter to the council to exceed the requirements of the Public Records Act and see if they could do this kind of special program. Go beyond what the Records Act requires and do this sort of synthesis and compilation. And that's what they did. If you look at these declarations, the amount of work that they did was substantial. It was beyond anything that they had ever done before. It was unprecedented. It was unrequired under the Act. We did this as a courtesy. This is the classic case of no good deed goes unpunished. Okay. You made a point. Okay. Also, if you look at other evidence, if you look at what happened after SPD, after I met, basically, or essentially, with Judy Endejan and with Tracy Fetter on March 23rd, we talked about this, and we talked about what the issues were. And after that meeting, Ms. Fetter still wanted this kind of correlation of information. She still wanted to put together incident information with the videos. She wanted more than just that Koban video database that Mr. Ratner asked for. She wanted this correlation. She wanted the two together. As a matter of fact, on the 23rd, when I wrote her an email telling her that we had a list of 10,000 CAD numbers, and the next step would be to identify the type of call, and they were working on an estimate of how long that was going to take in IT. This was a complicated matter. Ms. Fetter responded, how long before I can get the videos and the corresponding incident reports? She wanted them together. On April 5th, Ms. Endejan emailed me saying, Tracy wants a copy of all GO reports associated with 70 hours of video to sift through them. She still wanted that correlation. It was more important to her that she had all this information. This is absolute evidence that that's what she was asking for all along. It was reasonable for SPD to interpret her request differently from Eric Ratner's. Let's just look at this from a logical point of view. Why would SPD go on two tracks, simultaneously provide two different records to requesters, and risk a lawsuit like this if they didn't think this was a request for something different? The fact that Ms. Vetter months later has an epiphany and thinks, oh, wow, that's what I should have asked for, does not turn her earlier request into a request for something else. Indeed, she asked for X. Maybe she later thought she wanted Y, but the court has to recognize that Y didn't exist at that point either. We had to go through a lot of work to produce Y as well for Mr. Ratner, and SPD did. And we gave it to Ms. Vetter as soon as we recognized that's what she wanted. I want to address the 973 issue, because that is the real issue here. That's what's truly important.
Excuse me. On your 973 argument.
An agency, a law enforcement agency, is stuck between a rock and a hard place. First of all, we have the Public Records Act that imposes strict liability on the one hand. On the other hand, we have the Privacy Act, which makes it a crime to wrongfully disclose videos. We're walking this tightrope. We're doing what we think is the narrow construction of 973 in order to try to comply with both. First, I want to turn the court's attention to Bruce Hill's declaration on page 5 of that declaration. It states, all tag video that has been generated since the system was implemented, it's in the middle of the page, paragraph 1, unless otherwise lost during the 2 outages of 2008. We've never tried to hide the fact that there were these outages, are currently maintained in the Koban system. They're still there. Maybe the policy says they're going to drop off. They haven't dropped off. They aren't dropping off. It does say that untagged video stays on the Koban server for at least 90 days. It may stay there a little longer because of the disk space on the Koban system, which just drops off at a minimum of 90 days, but when the disk space gets to a certain point, it drops off. But all of this is still on the backup tapes for 3 years beyond that.
But you do agree, do you acknowledge that it is a catch-22 situation where the retention policy is 3 years, and you're talking about that you need to only release them after 3 years of the civil statute of limitations for personal injuries?
I don't think it's a catch-22. The reason for that, Your Honor, is you have to look at how the statute is written and how SPD is reasonably interpreted. First of all, tag videos are videos that are likely to lead to criminal or civil litigation. It's by definition in the retention statute. Now, someone who's the subject of the video, they get them. Someone's an attorney for the subject of the video, or their legal representative, they get them. Criminal defense attorneys get them. We do them in civil and criminal discovery. What we have is a statute, 973-0901C, which says no sound or video recording made under this subsection may be duplicated and made available to the public by a law enforcement agency subject to this section until final disposition of any criminal or civil litigation which arises from the event or events which were recorded. It's not a model of clarity. It's not the statute that any of us would want, but it's the statute we've got. It has two key words that need to be looked at to understand it. First of all, public. What's that mean? Public. That's very clear that public means something different from someone who has an interest in the video, the subject, an attorney, for example. And as a matter of fact, there are some real concerns about providing access to the general public regarding these types of videos that Tracy Vetter herself recognized in a piece that she ran on February 15th. She castigated a couple of SPD officers for showing a video of a traffic stop to the employer of an individual, thereby jeopardizing his very livelihood. Well, Your Honor, this statute is not about protecting police. This is about protecting the rights of individuals who have a legal interest in those videos. Whether it's,
well, I have a couple of questions. This statute is very difficult to interpret for a couple of reasons. And one of them is, isn't it the case that many times the videos and audio recordings that are captured by the police are in fact not private? Under case laws it's been defined, that many of them are.
Yes, Your Honor.
No.
Absolutely.
And do you believe the statute still applies in that instance?
Yes, Your Honor, I do, absolutely. And I think that the state, or excuse me, Lewis v. DOL case holds that way. Your Honor, the emphasis on privacy alone is misplaced. Yeah, it is a Privacy Act. I understand the nature of the name of it. But if you look at the Lewis v. Department of Licensing case, it says, as a matter of fact, what it did is it looked at the relationship, or excuse me, it compared custodial interrogations under 0901B with the type of traffic stop that they said wasn't private. And they said, there's no privacy expectation in custodial interrogation, but the police must comply with the procedure. We're told by the state Supreme Court that we have to strictly comply with the statute, or if you look at 973-0802, it says knowingly altering or erasing or wrongful, and this is the key language. It says to wrongfully disclose any recording in violation of RCW 973-0901C is a gross misdemeanor. The legislature not only meant it was important that these not be released, they meant it was really important. They made it a crime. And it says in violation of 0901C. Well, 0901C is the statute that says they shouldn't be given out until final disposition. Now, I'd like to address...
Let me ask you a question.
Yes.
Aren't you taking the position really that any possible civil litigation prohibits the release of videos rather than either probable litigation or ongoing litigation? I mean, isn't that the interpretation that's being adopted by the city?
I think it has to be, Your Honor. And the reason for that is we can't possibly know. I presented my declaration with an exhibit showing how often we get sued at the end of the statutory period. It's very common for...
I'm aware of that.
Right.
I'm aware of that because I deal with so many cases that cases are commonly not filed, although obviously the administrative filing would have to be done before that. So I think you would know for 3 years because you have a time period as well.
Possibly. They can bring their claim and then sue. I mean, or they can file their complaint and then wait to serve us for a while as well. That's common. But, Your Honor, the PRA requires us to narrowly construe exemptions. That's what we've done here. We have tried to apply the narrowest possible construction. Ms. Endejan, in her pleadings, admits this is a temporal restriction. The issue is how long. Now, the statute says which arises from. You just look at Black's Law Dictionary. That says which originates from or which stems from. That implies that it may arise later. It seems to me that what I'm really hearing from Komo is it has to have arisen already. That would just create a race to request these records. But just setting that aside, we could locate everybody who's on these videos and say, do you intend to sue? And today they could say, no. Tomorrow they could talk to a lawyer, they could go to the doctor and realize that their neck hurts. We can't know. We have this uncertainty. We cannot know. This is the narrowest construction we could possibly put on it. And temporal restrictions are common under the Public Record Act. There's a deliberative process exemption. There's real estate appraisals. There's an AGO regarding auditors' working papers during the course of an audit. Valuable formula and research data is exempt for 5 years. There are temporal restrictions. And the only issue here is whether the public gets it.
Well, I mean, if you have a video recording, let me take this a logical extreme. If you have a video recording of an act of abuse that occurs, I mean, statute of limitations for that is far longer.
True.
I mean, if there's a child involved, it could be to the age of their majority and beyond.
Absolutely, Your Honor.
But you obviously aren't thinking that.
No, and we could. Your Honor, if we wanted to stonewall, that's what we do. I mean, the most famous case on the investigative records exemption is Newman. And when I was at King County, I was the first lawyer to put my fingers on Newman. And Newman was 25 years old at the time of the request because there's no statute of limitations on a homicide like that. The court held it was still an active open investigation because they were still devoting resources to it. We could isolate out all of those potential claims and say, no, you can't have it forever. But that's not what we do.
And let me ask you one more question. Do you believe, I mean, for example, again, I'm just using the most famous example because I know we've all seen it, and it's not actually evidence in the case, but I think we've acknowledged we've seen it, the John Williams video.
Yes, Your Honor.
Do you believe that was under the Privacy Act, recorded under the Privacy Act? That's an in-car video, but there's no one in the screen that is there's no one-party recording going on.
Yes, Your Honor.
Do you believe that was covered by that?
Absolutely, because 0901C, if you read the Lewis case, says it creates an independent set of requirements that the agency, the law enforcement agency, has to follow, whether or not it's a private conversation.
All right, I know this is an important case, but the person who wants to get released from prison also says this case is important. So I need to divide up the remaining part of time. I know I've given you both a chance to respond and reply. So I'll give you each a total of 10 minutes to respond and reply.
Your Honor, if I might point out, and I pointed this out by pleading, they have improperly brought a cross motion. It is not. It is basically they're responding and opposing our motion for summary judgment. They're not seeking an independent basis. They're just rebutting. So I would submit, Your Honor, as the plaintiff in this case, I would like to have the last word.
You know what, there's a ambiguity in the civil rule, I think, on cross motions. It's been litigated in many cases, but I'm going to stick to what I just said.
Okay.
All right.
All right, Your Honor. Let me respond to what Ms. Perry said. First of all, what we're focusing on is what happened in the fall of 2010, the responses and the conduct of SPD in responding to Ms. Vedder's request. Ms. Perry tries to, and has the gall to say that they acted as a matter of courtesy to Komo after Komo went to elected officials and said, we think there's a problem here. So, but what they did in the fall was wrong and violated the Public Records Act. They didn't do a search. They submit that with respect to the video logs. All of a sudden they produced some declaration from some guy who said, oh, well, we think that she was asking for video logs that were referenced in the policy manual. That's not what, she didn't make any reference to that. And oh, and those video logs don't exist. Did they tell her that? No. What we have is one email to the wrong person in IT from Sheila Friend Gray responding or investigating that initial request. That's not an adequate search.
And I do understand you're focusing your
Right.
argument on a particular plan.
Right. And so, Your Honor, what happened in March is, I think, confusing and muddying the record. And